as you know, is a forum where it's a kind of conceptual rendering that we have. And we all are kind of experts, or at least believe that we are in our own field, but we have very little, if any, knowledge of all other fields. And this forum, this platform provides us opportunity to listen to the people in the other fields at a level where we can understand it. Of course, they are at much higher level. This event every month is sponsored by American Daisy Society, so-called ADS, and I'm very, very grateful to ADS for sponsoring today's talk. We bring very unique subjects, very unique speakers, and the setting is a classroom-like setting. Just as the title says, back to school, that means we have a teacher and we are the students, so we maintain the decorum of a classroom, hold our questions back, and then ask the questions towards the end. This is not supposed to be a debate, no arguments. It is a very supportive kind of platform with positive comments and editorials. So at the end of the day, it becomes a very, very positive, pleasant exercise. Not only we gain a lot of knowledge, you will see that you will find so many resources. Today, this is my great pleasure and honor to introduce Patrick D. O'Neill, ESQ, who's an attorney, and has a footprint that I could not believe that somebody can do so much work. And you look so young, Patrick, in their lifetime. He started with newspaper reporter jobs and photographer, and then went to service to developing countries, gained a lot of experience there, then practiced family law, estate planning, and now what is topic today going to be, wills and trust, and even probate. Many of us have no idea about most of these topics or most of these things, other than we know the title that there is something like family law, estate planning, etc. And then we have deeper questions about that. As I was preparing for his introduction, there was a very impressive line that he wrote about himself, and I would like to read it verbatim for you. Is, "I am here to be a participant." He's talking about his profession. "I'm here to be a participant and not an observer." And I think he's talking about his life as well, which is very, very profound, I thought. And I really thank you for sharing that line with us on your website. His offices are on the Feather River Drive, very close to Brookside, as you all know. So he's very approachable. There's a local number. And also he's an associate with Global Allianz offices of Atul Kapoor, who is with us tonight again. Everybody knows Atul. So you can say hi to them towards the end of the lecture. And as I said, please listen carefully. You will have a lot of questions. Please write down your questions. If your question is already asked by somebody and you already heard the answer, please go to the next question and just optimize our learning experience tonight. So without further delay, I would like to proudly present to you Mr. Patrick O'Neill. Patrick, microphone is yours. Thank you.
Thank you very much for having me, and thank you for that introduction. That's it's good to hear. It's and a little flattering to you know that you've done your homework. So thanks again for having me here tonight. As you've just kind of detailed, I mean, that's my background. I have a kind of an interesting path to being an attorney, but that's just exactly it. I was a reporter, and the job of a reporter is to observe and report. And I wanted to be more actively involved. So I went to law school. I also like helping people. So that's how I ended up in the area of domestic relations law, everything from your family law to your estate planning, and specifically to the purpose for tonight, wills and trusts. So that's where I'll kind of start off with. So wills and trusts are kind of under the broad umbrella of estate planning. Your full estate plan is going to consist of both a will and a trust, but the trust is going to be doing the heavy lifting. You'll also have an advanced healthcare directive. Sometimes people refer to this as a living will. And then you'll usually also have a general power of attorney, which is for fiduciary matters, to allow people to write checks in someone else's name, because it's the power of attorney. So it allows them to conduct transactions on someone else's behalf. Generally speaking, those are your four kind of building block documents of an estate plan. More specifically, as we drill down tonight on wills and trusts, these are two documents that will help to make sure that your wishes are honored after the fact, when you can no longer speak up on your own behalf, but you certainly want to make sure that the people that you love and care for are taken care of and receive the benefits of your life's work. So there are a couple of, I think, important distinctions right off the bat. A will is still going to subject you to the court process. In other words, for all of the terms that you include in a will to be operative and to make the distributions to your beneficiaries effective, you have to go through the court process. And this is what's commonly called referred to as probate. So that's what whenever you hear someone mention probate, it means that they had to go through the court process to get their inheritance, and it's called probating the will. So the advantage of having a trust with a will is that if it's set up right and correctly, you won't have to go to court, and everything will be outside of court. It'll be faster, and most importantly to a lot of people, it'll be private. When you have to go through the probate court for if someone dies with or passes away with just a will, it has to go through the public court system, and all of that documentation can be looked at by anyone. And so they'll see the value of your estate, they'll see the specific items that were distributed, they'll see who they were distributed to, and that will be a matter of public record. Some people, that's they're not all that concerned about it. Other people are more private, so that's more of a personal preference element. However, I can say that the probate process is going to subject you to a lot of delay, and it's going to take time. I mean, your average, especially nowadays, the average length for a probate case is 18 to 24 months. And you can certainly do that quicker if you have a trust that spells everything out. So to kind of touch on trusts, when you draft a trust, you have full control. You can dictate who receives what. You can be very specific in terms of itemizing distributions. I want my son to have this and my daughter to have that. You can also be less specific and create just general trust shares. And so that, I have 3 children and I would like them to each receive 1/3 equal share. You can do it that way. And then the best way to think about a trust in this sense is that it's a legal entity. So like an LLC or a corporation, a trust is a legal entity. And so it's like this bucket, and you can put things into it, and everything that you put into it is going to avoid probate. It's going to, be private, and it's going to be just contained into that trust, and specific, and more importantly, everything will be distributed from that trust according to the terms of the trust, which means that you get to set the agenda. You get to dictate exactly how things are going to be passed on. And more importantly, it gives you control to protect beneficiaries. Some individuals have, some families have special needs beneficiaries, so you can protect them with your revocable living trust and the general estate plan. So a trust usually, and I'm trying not to get into too many specifics right off the bat, but essentially, you can create the revocable trust that you can create additional trusts underneath that. And those trusts can be more secure. They can be harder for creditors to reach. And they can allow you to maintain qualifications for things like Medicare or Medi-Cal if necessary, and to protect beneficiaries from their own creditors. And so that way you can be sure that, if you have an heir that is, running into creditor issues, or, has substance abuse issues, or, other gambling is one that comes up. You can take steps in your estate plan to protect those people from the people that would come after your beneficiaries. And so it's a way of securing your inheritance for the benefit of the beneficiaries, and protecting the beneficiaries from people that would come after the beneficiaries. There are a number of different other advantages, kind of more practical advantages to having a trust set up. Probate fees for both the attorney and the individual that represents the person who is passed on are mandated fees and costs by California law. And so there's, if you need to retain an attorney to help you through probate, there will be costs associated with that. Just to kind of lay out the structure, the way that it is in the law is that the court tabulates the total value of your estate. So that's real property, personal property, artwork, gun, jewelry, coin collections, tangible personal property, investment accounts, everything that's subject to probate. They total it all up. And so that value of the estate then informs the fees that have to be paid from the estate. So just by California law, your cost of probates are going to be 4% of the first 100,000 value, 3% of the next 100,000 value, 2% of the value between 200,000 and 800,000, 1% of the next 9 million, and 0.5% of the next 15 million. And then it's discretionary beyond that, if you have an exceptionally large estate. So an example of, how does this translate? If you have $1 million estate, which in California, if you own a piece of real property and you have a couple of, retirement accounts, you're probably in this neighborhood, or close to it. So if you have $1 million estate in California, you're looking at very close to $50,000 in attorney's fees and fees for the personal representative. I think it's specifically 46,000. So that in and of itself right there is reason to set up a trust and a will to avoid probate, to keep it private and to avoid those fees. Another very important thing, I'm not sure how many people here are real property owners, but if you are, I think it's really important to consider a trust, because especially if you're going to be passing on property to heirs, there is the potential for capital gains taxes. So, if you purchased a house 20 years ago for $1 million and it's now worth $2 million, that would be $1 million worth of capital gains that would potentially impact your heirs upon receiving that piece of property. And so they would have to pay capital gains taxes on that. If you set up a trust where the property passes through the trust to the beneficiaries, you can get what's called a step up in basis. And by mechanism of passing that property in the trust, as opposed to just standard inheritance and through probate court, that property then gets a step up in basis. And so when that person when the beneficiary receives that property, they're receiving it with a basis of 2 million as opposed to a basis of 1 million. And so they're no longer subject to $1 million worth of capital gains taxes. They get it at zero. They don't owe any taxes on it. So that's a really crucial and key point of having a trust. If you own real property, it's just really, really important. There are other situations involving second marriages, or, I hate to say it, but, if one person wants to make sure that their wishes are honored, even if they're going to pass first, if they're married, the way we can set up trusts is that during the lifetime of the settlers, the people that make the trust. So presumably anyone attending, in this audience tonight, we set up a revocable living trust. And this means that you could get rid of it at any point. You could amend it. You can change it. You can do any, you can treat and handle and manage the assets in a revocable living trust as if you owned them as an individual, as opposed to holding them as a trustee in the trust. And so there will be no practical change as to how you manage your assets when you set up a revocable living trust. However, especially we see this often in remarriage situations, but it could, even come up in a first and only marriage situation. But if both spouses want to make sure that their wishes are honored, and that, they want to make sure that, okay, well, if I pass away first, 5-10 years later, my surviving spouse doesn't change their mind, and then all of a sudden our children get nothing. That's not what I want. The revocable living trust becomes broadly irrevocable when the first spouse passes. Some of the assets go into a second trust that the surviving spouse can manage, and that surviving spouse can do anything they want. They have the same freedoms as if it was revocable. So that secondary trust will be revocable as well, but they'll have the freedom with that. The other half of the assets go into the family trust, and this becomes irrevocable because these are the half of the assets that the deceased spouse owned. And so you're able to set the terms of that family trust before, at the outset, when we draft the revocable living trust. And that way, that even if you pass away first, that, pardon me, even if you pass away first, the terms that are, that dictate how the family trust is distributed and how it's going to the beneficiaries, that's set in stone. And so you can, you have peace of mind that you're protecting your beneficiaries. So those are, these are kind of your general benefits as to, the revocable living trust. On one hand, you're getting a lot of freedom and flexibility while it's revocable, while both settlers are living. But at the same time, you're beginning to lock in how you want your portion of the assets to be treated and to be handled and to be distributed, so that that even if something changes after you pass away, you will still have your wishes honored. I think the next thing that I would want to talk about, because it is, I have clients that come to us, sometimes they want just a will. They don't want the trust, and that's fine. If you're coming to our office with the intention of getting a trust, we'll also give you a will, and it'll be a slightly different kind of will. It'll be what's called a pour-over will. And the purpose of this will is really a trust backup. So you establish a trust, you put your assets in it, and then, you live another 30 years. You've acquired a lot of other assets. Maybe your family has gotten bigger. Excuse me. Sorry about that. You're able to go back and modify and make amendments. You can even restate the trust to make more material changes to it. But then in that term, if there's anything that you didn't change, say you acquired something and you forgot to title it in the name of the trust, that pour over will serves to keep your estate out of the probate court. You still have to go to court with the probate will, but what it does is instead of publicly disclosing all of your estate and having to go through the probate court or the probate process, which, like I said, is 18 to 24 months, you just say, you identify the trust of the court, you say this is his will, and the will directs that anything that was left out of the trust gets poured back into the trust. And so then everything just gets administered as if it was in the trust and without the court process. That's a single isolated court hearing, and then you don't have to do the probate process. But it's a way to catch any after acquired assets that, maybe there was a titling mistake or something like that. but that probate or that pour over will serves to put the assets back into the trust, or I should say, to put it into the trust overall, and then it just gets administered according to the terms of the trust. So that's kind of the overview of the wills and trust process. Like I said at the beginning of this, while I'd be comfortable saying that I'm sure everyone in this audience has similarities. I would bet my life on the fact that everyone in the audience has unique characteristics to their life and their family and their assets. And that's why, coming in for a consultation and really talking about, well, I want to make sure that, this beneficiary is protected because they have some of these issues. And I've got these assets and I want to divide them this way. It's really about crafting a trust that is that addresses your specific needs. And so that's really what we're here for. I'm fortunate enough to work with a tool over at Global Alliance. And so, we do free consultations, and, certainly want to encourage anybody, if you have a desire to I know there's a question and answer session, and I'm happy to move into that this evening, but for longer, more detailed conversations, if you think this might be something that's right for your family, your personal situation, we are offering free consultations, and it's a good chance to sit down with me for an hour and really kind of go through the specifics of your life and to determine what might be some of the best ways to protect your assets and to protect your beneficiaries, because that's really what this boils down to, is protecting your loved ones and then protecting your hard-earned life's work. So that's, like I said, that's kind of the general umbrella, the overview. I do want to get a chance to address some questions and everything like that.
Patrick, that was very informative. And as we start the question answer session, I'd like to ask you a couple of things, which are very simple and maybe it's common knowledge, but there are people, including myself, who may not have that knowledge. So on behalf of many of us, I'll ask you some simple questions. A curious question always is that if you will go sort of item by item to trust and will and poured will and such, that what's the cost structure that we are talking about here?
Like a cost for an estate plan?
Yeah. So how much would it cost me in general? I'm not going to hold you to that number, but approximate ballpark figure.
Certainly. So for a standard trust with a pour over will, that's going to be about $2,500. And then a full estate plan is going to be a little bit more at about $3,500. And that, like I said, that's going to include your power of attorney for other financial transactions, your healthcare or living, your advanced healthcare directive or living will. Those terms are interchangeable, and that's your, the healthcare directive. How someone, when you're incapacitated, receiving medical care, how are they? What are the what are your wishes that you want this person that you nominate as your healthcare representative to make for you on your behalf? But, in terms of the prices, I appreciate you, with the disclaimer mentioning that, you're not holding it to us, because there are certain case specifics, every case is different. And, some people have more complex situations than others. But, we really, the goal is to tailor something to your unique situation. So, we cater to your specific needs. And so, the price is, done accordingly based on the work that's needed to meet your needs. I do see, real quick, I want to jump in. I see a question in the chat. A will isn't mandatory with the trust, but it's certainly recommended, because, we can do everything correct the moment that we create your trust. We can put all your assets in, but, you might live another 25 years. And so, we don't, you might pick up more assets in 7 years and might forget to put it in the trust, or just, it might not be done correctly. You might be working with someone else at that point. But that pour over will is going to protect those assets that you get after you create the trust. So it really is, it's backup. So not mandatory, but certainly recommended. And
So I saw a note from your business alliance, Atul Kapoor, that the first 30 minutes of the consultation are going to be the free on one-on-one basis when you do it.
mhm.
Does that apply to you as well, or this is only for Atul?
No, so I'm associated with a tool and Global Alliance. So that's they're fortunate enough to, or I'm fortunate enough that they share some office space with me. So it would be with me and Global Alliance.
Okay. My
So
last
it's a
question.
package deal.
Yeah, sure. Thank you. My last question on this round of questions is that, so I understand that you can, or one can completely avoid probate if we do the homework. One, you said that, we form the trust and put everything into a trust, define everything right up front, both by the revocable and irrevocable trust, but we control the whole process. And then second was you said that we can have just a trust with the poured will to have a second level of protection.
Mhm.
Because the probate process can cost up to $100,000 only on $1 million worth of your estate.
Not quite. It's there's a statutory fee. It's 4% on the first 100, 3% on
Yeah.
the next 100, and so if you had $1 million estate, it would be
Yeah.
about 50,000 total.
Yeah.
That's
So
going
total
to
will 50.
yeah.
Okay. So what about between, there was the next level, 1 million to what was the next level?
Oh, it's once you get to it's 2% between 200,000 and 800,000, and then it's 1% of the next 9 million. So
1% of the 9 million, yeah.
yeah, so as the estate gets larger, the increments get larger.
Yeah. So does it go down to 250,000 or less, or the 0.25% or less for 10 million or up?
So yeah, so then it's 0.5% for the next 15 million, and then if you have an estate that's beyond that, it's at the court's discretion.
Okay.
So but you'd be talking basically, if you have an estate worth more than 25 million, and you went to probate on that, the first 25 million, the fees fixed for the first 25 million would be fixed, and you'd be able to clearly identify that. But then anything beyond that ability would simply be the court's discretion and what that attorney petitioned the court for. I think we can all safely assume, if you have an estate that is that large, there's probably going to be a fair amount of attorney work involved in navigating the case through probate. So you could see the attorney requesting extraordinary fees above and beyond that.
Yeah. So that was not my personal question, by the way. So don't get me wrong.
No, I was
I have any stretch of imagination, but I have on my screen people that I would like to ask a few questions on their behalf, and I did. So this is my question. Okay, I'm open.
Deepakji, it was a nice joke.
I know, I was like, adopt me for that kind of, add me to the trust.
Deepakji, nice joke.
Oh, I wish I could, if I could pull that one. Ready for the other question, please.
Girsha has a question typed up.
Yeah, I was just going to see one in the chat here. So certainly, if you have a revocable trust you've set up before, happy to look over it during a consultation, and again, kind of have the same conversations that we would have initially, in terms of what figuring out your wishes, but then seeing how your wishes match up with this old trust. And this is where you get into, there's kind of a fork in the road. So you might have some slight changes that you want to make. In that case, we could just draft an amendment. An amendment is, a page, 2 pages, and that keeps it, pretty simple. Just basically spelling out, on this date, I want to change this, this, and this. There are some changes that are a little bit more significant. Say you want to take out a beneficiary entirely. Something unfortunate happened, and there's been an estrangement. That would be a situation where what we would do is what's called a restatement of that trust. And the reason that we would do that is that one, an amendment wouldn't be sufficient to strip a beneficiary of all their inheritance, especially if there's an old trust document. But when we do a restatement, we can change big material portions of the trust, for instance, like a beneficiary, without changing the name of the trust. And this is important because all of the assets, whether they're bank accounts, real property, the title to the house that you're living in, if those are all titled in the name of your trust, we don't have to go through it. We don't have to retitle everything. What we do is we just restate the document. And so the trust name stays the same. And in fact, a lot of the provisions will stay the same, but some of the specific material changes that you want made will replace the blocks of language in the old trust. And so, yes. So the short answer to that question is yes. If you have a prior revocable trust and you want to have that analyzed and you want or updated, absolutely feel free to make an appointment with us and we'll go through it together.
Wonderful. Thank you.
You're
Other
welcome.
questions? Okay, there is another question there, Patrick.
So this is a good question. Basically, you have to set up the trust in a way that that restricts the income going to the beneficiary so that they can remain qualified for Medicaid. Otherwise, if they're in their specific language, you might have, I'm not sure if you've ever heard of the HEMS standard, HEMS, it's Health, Education, Maintenance, and Support. Depending on how the language is inserted there, if the trust allows essentially excess distributions to a beneficiary who might, be eligible for Medicaid, if too much money goes to that person, and if the wrong language is used, then that can ruin their ability to qualify for Medicaid. There are also important things to consider when you set up a trust like this to protect someone's eligibility for public benefits like that. There's what's called a look back period. And I apologize, I need to double check this, but it's either a 3 or a 5 year period in California right now. And so what it does is it prevents you from at the last minute setting up a trust to, basically preserve someone's Medicaid eligibility. At the last minute, like say like a year before they were eligible or went on Medicaid, the federal government will actually look back, 3 to 5 years in that person's tax returns and income history. And so that's something that you need to plan for in advance because of that look back period.
Thank you. Other questions, please? Okay, there is one.
Yes, you can. That's a little bit, that's more of a funding question in terms of getting the assets into the trust, but you can certainly identify the assets as belonging to the trust as part of the distribution, where you would get into some kind of trickiness is making sure, if the assets are foreign titled assets, you need to make sure that they, you'd have to go to the source, the foreign country and make sure that the assets get titled that way. But there's certainly nothing wrong with including them in the trust and having them being part of the distribution plan. Yes.
Will the foreign government agree to this, to the trust made here in US for that?
I'm sorry, can you say that one more time?
Like for the foreign country assets,
Mm-hmm.
will the foreign country agree, or will that be an official, the trust will be an official paper to submit?
So, yeah, so one of the kind of the tangential documents that will come with a trust is what's called a certificate of trust. So this is a shorter form document. A certificate of trust is anywhere from 2 to 5 pages, much more portable, because a trust can be quite lengthy. It could be tens of pages long, and as opposed to hauling around the actual trust to financial institutions or other places, we draft a certificate of trust which lists all the particulars, like when the trust was created, what the name of the trust is, who the trustees are, who the successor trustees are, and who has the authority to act, And so it's this very kind of almost bullet point reduction of the trust. And you give that to the institutions that you need that are managing your assets. You say, I want to put this asset into a trust, and here's all the particulars. And I will caution, I will say, because I've heard this from clients, and I've actually had this happen with my own trust personally. So I drafted my trust, and I had my certificate of trust. I went to open a bank account at Wells Fargo, and I presented them with my certificate of trust. And the banker said, I need you to fill out this certificate of trust. And it was a Wells Fargo internal form because their legal department just was tired of their bankers having to do the evaluation of certificates of trust that were prepared by attorneys. They were like, we're just going to have our bank create a form, and that's the form that we're going to go by. Now they're kind enough, they didn't, they provided a notary for me in the branch and everything like that. So I didn't have to do anything. They just wanted it on their form. So we'll prepare and draft a certificate of trust for you. But I just want to caution everybody that you could easily be subject to the whims of the financial institution. They might say, we want you to fill out our form. And, that's just it's up to them. I see one more question. If someone already has a living trust, can it be amended to incorporate the Medicaid triggers? Absolutely, yes. We can change the terms of, and that's something that would be, actually, I guess if I can be more specific with my language, I would say that would require a restatement because that's a more material change. But we could still use your old trust, keep the same name, and you wouldn't have to do anything with the assets. Everything could stay where it was. But we would want to restate it to change the terms so that, that you could preserve that Medicaid eligibility.
Thank you. Any more questions? Audience, any more questions, please? Okay, as you got thinking about your questions, because I have experience when we start closing the session, that's when people start asking questions, and then it goes for an hour. So I'm just trying to see if everybody, there is one. What's the difference between the trust and estate?
Oh, so that's just, estate planning is kind of the broad term, and that includes everything, from your healthcare directives, your financial powers of attorneys, your will, whether it's a will or a pour over will or a full trust. And so all of those things that I just mentioned are like pillars that hold up the estate umbrella. And so the estate plan is a more broad term. A trust is a specific instrument within an estate plan. You can have a trust without an estate plan, but you can't really have an estate plan without a trust.
That's true. Thank you. I'd like to hear your comments on an instrument that I have heard of, and I thought that I'll ask you that question today. What do you think about the vacation home trust or the spouse support trust?
So, I haven't looked into a whole lot of, specifics in terms of, separate properties. I generally, my preference is to include everything into into the same revocable trust, if the people own it. One thing that I would say, and this, because I practice family law, I see the other side of things, the separation, the deconstruction of a unit, if you will. Just putting something into a trust doesn't necessarily change the characterization of that piece of property. So if you, and we can include specific language there, we're intending that everything should be community that we put in here, or we intend that everything should stay the characterization of the property that it was when it went in. So like if I put something that's my separate property in, say it's a separate vacation home, that will remain mine, but we can still put it in the trust. So, if it's a commingling of assets thing, I would say that put it in the same trust, but include specific language that says the characterization of this property is this. But it could still be in the trust, and that way it makes management and administration easier. The flip side of that is there would be nothing wrong if you wanted to put it into a separate trust. Yeah. It's just a second entity to manage.
No, that's very convincing. Thank you. There is a question there, and I have one last question from me on this round.
Yes, I do generation skipping trusts. I'm also, I also should note, I'm a member of the National Network of Estate Planning Attorneys. And so the software that we use is drawn on, first of all, it's California specific because we live in California, but it's drawn on like 100 years of knowledge of estate planning attorneys from around the country. And so we do, I mean, any, the generation skipping trust can be, elements within the trust document that we do. But yes, the short answer to that is that we do generation skipping trust. And you had, I think, one more question.
Yes, I do have. So how can we, well, let's say in context of probate, or, most of the time the person who fully understands it and has created the instrument for the benefit of the survivors, he's the one or she's the one who passes away, and there's nobody knowledgeable. So how the beneficiaries can be protected from the frivolous creditors and people who come and claim liens on the property or other assets?
So if it's if everything is in a trust, then it's up to that trust administrator as to whether or not to honor that claim. Now, I will say, just like the trustee, those people owe fiduciary duties to the grantors, to the people that created the trust, even if they have passed and they're no longer here. And so the terms that are contained in the trust are ironclad. The trust administrator and the trustee have a legal obligation to see that those terms are lived up to and honored. And in fact, if they don't, the beneficiaries would have recourse against the administrator or the trustee for not acting in their duty. So to get to the more specific details of your question, that trust administrator would look at that claim for a creditor claim, and they would make a determination as to whether or not it was bona fide or whether it was a scam. If they refused, the only recourse that creditor has is to open a probate case against the trust and to get a court to rule on that. And so that's a potential situation where it could end up in court. It's a similar process if if you don't have a trust and you're going through probate. One of the reasons probate takes so long is there's like a 4-month dead period where nothing happens. You just wait for creditor. You've published
to come forward.
Yeah, you're waiting for creditors to come forward, and sometimes the personal representative will pay small stuff like just without making a big deal about it. But otherwise, those creditors have to submit a formal claim to the court, and it's part of the court record. And then if there's a dispute, then it just goes before the judge.
Okay. Well, thank you. Just to follow up, is that how much information beneficiaries have to have, and how much I have to share with them or anybody who has the trust or the planning with them, so that once the member passes away, the person who created the trust passes away, so that the beneficiaries can reach them out and give the details. So is it sufficient to just know the law firm's name, the attorney's name, etc., or do you have to give a lot more details?
So what I like to do is I like to have my clients, and I work with them, oftentimes like I'll draft it and they'll read it over. But I like to draft a letter of intent or a letter of instructions to the beneficiaries. That's like a cover to either just the trust or the estate plan that takes this complex legal document and really spells it out in layman's terms over the course of 1 or 2 pages. It's like, this is what I'm intending. I want these people to be taken care of, and I want most of my assets to go to this particular section, has all the terms that accomplish this. And then, certainly encourage all of my clients to have conversations with their families. I will always have a digital copy of the trust, but the clients keep the originals. They have, you've got the notarization and everything like that. And then our contact information with the law firm will be there. But, I certainly encourage people to have, some open conversations with their beneficiaries, but also at the very least to have like a cover letter that says, this is what I'm trying to do, and this document does these things.
Okay. I think this answer will benefit a lot of our audience tonight, because these are some of the questions that we don't know. And I have seen things happen in families when the survivors have no idea what to do, where the money is, if there trust, no trust, and a lot of confusion for months before things get discovered. So there is another question in the window there in the chat box.
Certainly, and just to kind of put a bow on that last point, we certainly are open to, and in fact we would like to be the people to help on the back end as well, so to help administer the trust and protect the beneficiaries and help everything get distributed after the fact as well. So we certainly view this as a holistic process. I mean, from start to finish, we want to help you get everything set up and get a plan in place, but also to make the process, at the end, smooth. So it's certainly something that we hope that people consider. Two quick questions here. So a particular age when we should do a trust. I would say not so much an age as depending on how your life is progressing. So, maybe you don't have a lot of assets, but you have a wife and children, or a husband and children. You'll want to put some parameters in place. Should something happen to the two of you, who's going to take care of the children? How are our assets going to be protected so that they'll get to receive the maximum value when they turn 18, et cetera. The other similar, kind of measuring stick there as to when you should get a trust would, family would be one consideration. The other would be assets. So I would say, if you're about to purchase your first house, you would want to put that into a trust. And this actually gets to a good question. So, people will ask, because, I've just got a house and, I'm just beginning my career. I don't have a whole lot of assets, but I do have a house. And we'll just use for the purposes of this argument, say it was $1 million house with like a $950,000 mortgage. So there's only $50,000 in equity there. They're like, I don't have a whole lot, why should I put it into a trust? Why, who cares if it goes to probate? The value a court is going to set on the value of your estate in probate is the gross value and not the net. And so you would, in that particular case, you'd have the value of the probate being $1 million. And you've only got $50,000 worth of equity, and you'd all of a sudden be looking at $50,000 worth of fees because you have to go through the probate process, because it doesn't set the value on just that equity. It sets it on the whole, it sets it on the equity plus your mortgage. So the answer to that question is really like, when you start accumulating assets or, building a family, it would, so it's not so much an age. Administration of a trust involves considerable work. Yes. So there usually what happens is there are reasonable compensation provisions for a trustee of a trust in the trust. A trust administration, unless there's a dispute or unless something went wrong, a trust administration shouldn't go before the court. So it's just going to be set according to the terms of the trust. And usually what you see is that family members are the successor trustees. And so they also happen to be beneficiaries. And so they don't take a fee. That's usually what happens. But there are provisions in there, sometimes if a successor trustee passes away and so, or they're just unable or unwilling to serve, there are provisions for an unfilled trusteeship. And then you could get a third party in there and they would have to be compensated for their services.
How much is the standard compensation for a trustee?
It usually tracks along with probate fees. That's just generally what you kind of the rule of thumb. But I mean, because it is your trust, I mean, you could theoretically, draft provisions in there that say, I don't want my, trust administrator to be paid at all. That could lead to some sticky situations and some contests in court, but usually it's not a big issue because most of the time you don't have a third-party trustee administering the trust. Now, that's a little bit different than going out and hiring a professional to administer the trust, because a professional will require some fees, and then it will be them that sets the cost. You see a couple of different, you see usually one of two things. A trust administrator will charge based on the percentage of a percentage value of the overall estate. And if that's the case, the percentage that they charge should closely track the probate fees that we discussed in the code. It should be very similar, in fact, it should be, which I would say it should be less, because you're not going to court. And then the other option would be standard hourly fees. But if a trust administrator was going to, request standard hourly fees, you would want a pretty accurate estimate of what the work they thought they were going to do, because again, it should be less than the statutory fees for probate. The statutory fees for probate are usually going to be a good starting point, and you're like, okay, I've got a trust, it needs to be administered, not going to go to court, there's no disputes, no contests.
Any other comments, please?
Yeah.
Okay, you're none. So on behalf of all the audience today, Patrick and ADS, I'd like to profusely thank you for appearing today here and sharing your knowledge and wisdom with us. I think you have a great personality, I would like to say, and you are able to establish the rapport very, very quickly with the audience. And took the question answer session very well. So most questions are very well answered, in the sense that the questions that we asked, that's what the answer that you will get. I'm very, very grateful to Atul also to introduce you to the ADS. Atul is very, very active member of this organization. You know that we are a charitable organization and have done a lot of work in the community in the last 1 year or more. And it's been well recognized at this point. So I'd like to welcome you to continue to meet on this forum, and this is always open for you. And I'm sure that in future, when you come back, since now you have set the stage and made this audience a little knowledgeable, that they will be asking you more and more questions. I must tell you that I learned a lot tonight from your conversation and also from the question answer sessions. So thank you so much. And on behalf of everybody, I would like to thank you again.
Thank you very much.
Yeah, we have a question from Satish ji. They would like your information, Patrick, your contact number and everything. If you would like to type it in the chat.
Oh, I would say just direct all inquiries to Global Alliance, because that's what I'm working with a tool through Global Alliance. So as long as you've got the contact information for Global, then that's the best way to get a hold of us.
Sure.
Atul, if you are online, can you announce your office phone number, please, so that people, if they would like to have it handy?
I'll send it in the chat. I had sent it in the chat before. I'll send it again.
Yeah, please.
Here we go. Yeah,
Okay, there it is. And that is 209-670-5384.
Yeah, that's my cell phone number. They can call me on this one.
Yes, Global Allianz Law Firm, LLP.
Yes, sir.
They are offering 30-minute free consultation to look for a new trust, or even check your old trust to make sure they meet the standards. Girja, you have a question?
Yes.
Go ahead.
Yes, good. Yeah, I just wanted to thank, and I'm really appreciating, this is very timely forum for us, and I can't thank enough for all of you. And I did write the question, the people who asked, the answers, absolutely, and organizers. You really pulled off a great one. I really did learn a lot, although I'm familiar with it, but there is always more questions to be answered.
Yeah.
Thank you, all of you.
We love having
welcome.
you, Girja. Thank you.
Thanks.
Thank you. Thank you.
Thank you very much. It was a great presentation. Thank you.
Thank you. You're welcome.
Any other questions, or Deepak ji, I'll leave it up to you.
No, actually, I would let him go. He's not kind of feeling well in terms of his speech, so he needs a break. So, Patrick, you are done, and I'll leave the forum open for people if they would like to socialize. Thank you.
Excellent. Thank you. Thanks so much for having me. It was
Thank
really nice to
you.
see everyone.
We'll have you back.
Thank you, Pat. Have a
you.
good night.
You're welcome. Have a good night.
Thank you.
All right, we have our social hour now, huh? We can ask unofficial questions.
Well, we really are.
Meet, while COVID is still going on, so everybody can unmute their microphone and talk.
Yeah, everyone can unmute and talk. Everyone can unmute.
Yeah.
I finally got a trust done 2 years ago. I said it was on my mind for almost 15 years, and we never got time to do it. And I don't know what happened. I panicked one year. I was like, the very first attorney I get, I'll do a trust. But I wish I had known Patrick at that time, so we could go much, because it was a standard trust done. There was not much consultation, not much like what I need or what our family needs. So to have a custom one would have been great.